Hi, everyone. We'll just give others a few minutes to join and then we'll get started. Okay, so I think we'll get started. Good afternoon, everyone. Thank you for joining us for our Citizenship by Descent pop-up webinar today. Today we're joined by panelists Hilete Stein and Valerie Kleinman, who will provide us with the latest developments in Canadian citizenship by descent and how your family history may impact your eligibility. Please feel free to ask any questions using the questions icon at the top of your screen. We will do our best to address them at the end. If the panelists do not get to your question, you can contact them through the information provided on the screen. With that being said, I'll hand things over to Hilete and Valerie.
Thank you. So we're very excited to talk to you today about a very hot topic regarding citizenship by descent. If we can flip to the agenda slide, we'll just run through quickly the topics that we will be going over today. So we'll start off by going over what is Canadian citizenship by descent, what changed with the removal of the first generation limit, or the change to the Lost Canadians provision, as some of you may know it. What happens with children who were born after these changes took effect on December 15th, 2025? Do Canadians who are citizens by descent have to actually apply for their citizenship? Does Canada allow dual citizenship? And we'll also touch on some of the implications of these legislative changes for children who were adopted by Canadian citizens. We'll also talk about some of the challenges resulting from changes to Canada's legislation on citizenship by descent, including, how does frequent travel affect eligibility for future children, issues that have come up for people who are now suddenly retroactively recognized as Canadian citizens, and then we will open it up hopefully for some questions at the end. So thank you everybody for joining us. So just to kind of give a little bit of background, there are three ways to acquire Canadian citizenship. So one way that one would acquire Canadian citizenship is by birth. So a baby born in Canada is automatically a Canadian citizenship, a Canadian citizen. You can also acquire Canadian citizenship by naturalization. So that would be for people who immigrate to Canada, live here for 1,095 days, meet all of the other requirements to become a citizen, and they would need to apply for a grant of citizenship. The third avenue to be a Canadian citizen is by descent. So this is for people who are born outside of Canada to a Canadian parent, and that parent may have been born in Canada themselves. They may have naturalized in Canada, applied to become a citizen before the birth of this person. Or more recently, we'll get into discussion of people who are now citizens by descent, who were born outside of Canada, to somebody who more recently retroactively became a Canadian citizen. So people who are Canadian citizens by descent, this is also automatic, like being born in Canada. Okay. Now, from 2009 to 2015, the legislation that was in effect effectively put a first generation limit on the ability to pass citizenship down by descent. So Canadian citizens born abroad could not pass citizenship on to their child who was also born abroad. citizenship by descent effectively stopped at the first generation born abroad, so that only first generation children born abroad could become Canadian citizens by virtue of their parents' Canadian citizenship. The 2015, which was sort of the last most recent version of our Citizenship Act, was changed on December 15th of 2025. And on that date, legislative reforms came into effect that it removed the first generation limit because this limit was found to be unconstitutional by the Ontario Superior Court of Justice in 2023. And the effect of these legislative changes from December 2025 are that citizenship can now be passed down to multiple generations born outside of Canada to a Canadian parent. So it doesn't just stop at the first generation born abroad. This citizenship by descent can now be passed down beyond the first generation. So many individuals who were previously not considered to be Canadian because their Canadian parent was born outside of Canada are now automatically being recognized as Canadian citizens retroactively, as if the previous limit never applied. And this extends actually even further because we now have many individuals who have parents that were not previously considered to be Canadian, but under the new legislation, they're now recognized as Canadian dating back to their birth. And that means that their children are now also considered to be Canadian. So in terms of looking at how this applies, there's a difference depending on whether you were born before the new legislation came into effect, so before December 15th, 2025, or if you were born on or after December 15th, 2025. And Valerie will talk a little bit about the difference in terms of, when you were born.
Right, thanks, Lee. So this is a really pivotal date for us, December 15th, 2025, and it's when the new rules came into effect. And it basically created two different paths, people born before that date and people born on that date and afterward. So for anybody born before that date who is a direct descendant of a Canadian, so a child, a grandchild, a great-grandchild, and sometimes even further beyond, they would be a citizen by descent. So by virtue of the new law, they are a citizen by descent. This includes, people who now, as Hilete mentioned, their parent is now retroactively considered to be Canadian. Even if their parent has passed away, they would still be a Canadian. They're considered to be Canadian since the date of their birth. But children who are born on December 15th, 2025 onwards, so basically anybody who is now born is subject to a more stringent test. So not only do they have to have the proof of lineage, so showing that their ancestor was born in Canada, and there's a direct line between that ancestor and themselves through a series of birth certificates, but they also have to show that their parent had a substantial connection to Canada before they were born. So if somebody, was born last week and their parent is a first generation Canadian born abroad, so that meaning their grandparent was born in Canada, their parent was born outside of Canada, and now they were born outside of Canada, they are the second generation onward. They have to show the direct lineage, but they also have to show that that their parent had a substantial connection to Canada before they were born. And right now this is being interpreted as having spent 1,095 days in Canada before their birth. So as you can imagine, practically this is quite complicated because firstly, it's a brand new rule. So people would not have known that they had to document this through their lifetime. They also, in some cases, we're dealing with third generation, they wouldn't have even known the second generation person that they would one day be considered to be Canadian. So this is really not something that anybody would have been thinking about. And so, this is a relatively new thing. We are going to see how this plays out, but effectively, people are expected to provide dates of when they were in Canada, when their parent was in Canada before their birth, and supporting documentation to demonstrate that they were in fact in Canada. So there's situations where we can imagine that's easier to do, where perhaps the parent went to university in Canada for 4 years, but there are others that are going to be more difficult. You know, maybe they spent a year in Canada when they were a toddler and then spent, 6 months here and there. I mean, that's certainly going to be more difficult to prove. So certainly moving forward, this is something to think about for people who may have children in the future to document their time in Canada. So this brings us to the next question about what do we do? What do we do now? I think I'm a Canadian. Do I apply for citizenship? How do I proceed? So as we discussed, many of these individuals already are Canadian by virtue of the law. A little bit different with those born after December 15th, where there is additional evidence that has to be provided to prove that they are Canadian. But in either situation, we're applying for a citizenship certificate to prove that the person is a Canadian citizen. And when that certificate is issued, it will show that their date of citizenship is their date of birth. And so, this is an application where, again, we want to show the connection between the person born in Canada. We want to demonstrate that they were born in Canada and show the familial link between each generation to prove that this person is a direct descendant. Once the certificate is issued, the person can then apply for a Canadian passport. They can obtain a Canadian social insurance number. It is proof that they are Canadian. Right now, the processing time for these applications are about 10 months. This is an average, so we do see cases that may take longer and some cases that are faster. There's also the option in certain circumstances to request urgent processing. In some cases, there are quite urgent situations where perhaps somebody has a job that they need to begin in Canada. They have studies that they have to, begin in September. And it raises some complex issues because maybe previously this person would have applied for a work permit. But as a citizen doesn't need a work permit and can't apply for a work permit. So we do have these situations arising. There's all kinds of scenarios where people very urgently need to be in Canada. They need to be able to obtain their social insurance number so they can start working. They need to accept their admissions to a Canadian university. The university needs to know if they're Canadian. They need to know whether they need to ask the person for a study permit. They need to know what tuition to apply because Canadian citizens pay much less in tuition compared to an international foreign student. So there are a lot of situations where there may be a strong argument for urgent processing and where that needs to be requested because 10 months is not going to work with a timeline of, whatever situation is going on in somebody's life.
Right. And it's interesting, Valerie, just to jump in here, we are starting to see cases in particular from, American citizens who, in the past would come to the border to apply, for their work permit or their study permit potentially. And we are starting to see officers ask questions about Canadian lineage. And if you have, a Canadian-born ancestor and potentially, a claim to Canadian citizenship, that officer may not be willing to issue you a temporary document because you are no longer a temporary resident or a foreign national. You are now actually a Canadian citizen. Just you don't have the proof yet because you have to apply for your citizenship certificate to prove it. Okay, so the change is really, it's retroactive and it's a recognition. You're not applying for your citizenship. You are a citizen who now needs to apply for that proof in order to obtain certain benefits as a result of that. So very interesting scenarios that we are seeing and certainly the urgency request in those situations, it is key when we're putting in these proof of citizenship applications to make sure that we can continue to meet, timelines that are needed to prove status.
Yeah, and an added, scenario to be aware of as well is the issue of traveling to Canada. Even, as coming on vacation, a Canadian citizen needs to travel on a Canadian passport to come to Canada. There are some exemptions for dual nationals of Canada and the US, but citizens of any other country that also hold Canadian citizenship cannot board an airplane to Canada without a Canadian passport. So there are all kinds of implications for people discovering that they are potentially Canadian, who are Canadian, and their ability to come to Canada, even just for a vacation. So important to be aware of that. And then I think that brings us maybe into into our next question, Hilete, if you want to talk about whether Canada allows dual citizenship.
Yeah, so I mean, Canada absolutely does allow dual citizenship, and that's sort of the short answer to the question. But the questions we've been seeing in that regard sometimes relate to people who are from countries that do not recognize dual citizenship, or we have also seen questions from people who hold high-level positions in certain foreign governments and military that are prohibited from having dual citizenship as a result of the nature of their positions. So for people who suddenly, as a result of these changes, are now being recognized as Canadian citizens, there is a simplified renunciation process for people who automatically became citizens because of the change in the legislation in December. Those people can apply to renounce their Canadian citizenship if needed. But, again, this, relates back to some of the practical challenges that we're seeing in terms of timelines and things like that. But the short answer is, from the Canadian side, yes, you can have dual citizenship. In terms of adoption, so the process for children who were adopted abroad by a Canadian parent is a little bit different than what we've been discussing up until now, where if you were born abroad to a Canadian parent, you're now automatically recognized as a Canadian citizen. For adoption, the process is a little bit different. Those children would need to apply for a direct grant of citizenship rather than being recognized as a Canadian citizen dating back to the date of their birth. Okay. So with children who were born abroad to a Canadian parent, those children automatically are considered to be Canadian. They need to apply for proof of citizenship, as we discussed, and the proof is the citizenship certificate that would be issued at the end of that process. But they are considered to be Canadian effective the date of their birth. For children who were adopted by a Canadian parent, or a parent who now retroactively is recognized as a Canadian as a result of the removal of the second generation limit, they can now apply for a grant of citizenship through a direct grant process, which really involves two steps. So the first step, they would need to show that their adoptive parent was Canadian at the time of the adoption. And then the second step would be obtaining the grant of Canadian citizenship. And like with people born to Canadian parents, with the adoptive children who were born on who were adopted on or after the coming into effect of the new legislation on December 15th, 2025, the adoptive parent would have to show that they had accumulated 1,095 days of physical presence in Canada prior to the adoption. So, similar criteria, but a slightly different process. And, we have seen scenarios with adopted people who are now adults where, the parents are now retroactively recognized as Canadian citizens based on these legislative changes. But because this grant, which they're now eligible to apply for, will not be issued retroactively to the date of their birth. If they already have children, they cannot pass citizenship on to their children. So, this really kind of differentiates, in some ways, the effect of the change in legislation on people born abroad to Canadian citizens versus adopted abroad by Canadian citizens.
Right, and in those scenarios, they'd have to look at other options. So if they have an intention to move to Canada, they could look at sponsoring their child for permanent residence, so long as the child is under 22, and their spouse potentially as well, if they have a spouse. And there is an accelerated process for a permanent resident who has a parent who's a citizen if they're under 18. So that, that might work for them. But it does, we do see situations where we have families with biological children and adopted children. And this has been one of the criticisms of the new legislation, is that it hasn't really dealt with this issue that existed before, just with first generations born abroad and others. So it is, an ongoing issue that we have family units where children their rights are different, they're treated differently, they have different processes.
Right. Another question that we've been seeing recently, so we do have people who have applied prior to the change in the legislation for Canadian permanent residence. So, we've seen situations where, you apply under the Express Entry program, or you've married a Canadian and they applied to sponsor you, and you had a permanent residence application in process when the legislation changed. And the applicant may now actually be a Canadian as a result of these changes. So we've had people come to us saying, well, I've got this application in process. What do I do here? And it's very interesting. So if you are the only applicant on the application, effectively you need to apply for proof of your Canadian citizenship if you are now retroactively a citizen. And that permanent resident application would go on hold until you can provide proof that in fact you are a Canadian citizen. But if you applied for permanent residence with your spouse and your children, the children, if you are a citizen, would also have a claim potentially to Canadian citizenship, but your spouse does not necessarily have a claim to Canadian citizenship if they themselves don't have Canadian lineage through their family line. So a spouse who's included on a dependent permanent resident application may not actually be able to proceed with that permanent resident application. So this can actually delay their permanent residence process until the principal applicant, who's now considered to be Canadian, gets proof of that Canadian citizenship status, and then they would have to kind of start the permanent resident process over for their spouse and apply to sponsor them. So a lot of practical challenges coming up that we're seeing, from many of our clients as a result of this retroactive change. And it's really interesting to see how these will play out as we kind of get further guidance from IRCC on how to deal with these situations, and maybe some of the unintended consequences or challenges of this retroactive change. I think at this point, Valerie, we can turn it over to some questions if there are any.
Yeah, so we have a number of questions. So Hilete, maybe you can answer this one.
Sure.
Somebody who applied for a citizenship certificate before the law changed and their application hasn't been finalized yet, will they be processed according to the new legislation?
Yeah, so we didn't touch on that actually, but before this new legislation changed on December 15th, we did have a discretionary application process for people who thought that they might have a claim to Canadian citizenship, where they could apply for a discretionary grant of citizenship based on having a Canadian ancestor. Those applications remain in process, and IRCC has indicated that they will be processed in accordance with the current legislation. So they will be assessed based on the new legislative change, meaning that they will not be granted citizenship. They will be given a citizenship certificate effective the date of their birth.
So there's a couple of questions about parents naturalizing. So if somebody has a parent who becomes a naturalized Canadian citizen after they are born. So in that scenario, and then we're talking about adult children. The adult children are not Canadian citizens. So if I'm an adult and my parents tomorrow become naturalized Canadian citizens, that does not give me any rights as a Canadian citizen. If I'm a minor,
that's
maybe my
just
parents,
because it's not dating back to, they were not Canadian when you were born.
at the time of my birth. Yeah. That's right. And the same would be with an adoption too, right? They have to be Canadian at the time of the adoption to have direct access to a grant by adoption. So generally, if it's a minor, then generally they're being included in an immigration application, and then, you know, there's options for naturalization after. There was also another question about just a scenario with a grandmother born in Canada who moved to the US in their childhood. And yes, that's exactly the kind of situation that we're talking about. So the grandmother moved when she was a child, and so she then had, you know, children later on. And so those children, and in this case, we're talking about a grandchild as well, are quite possibly Canadian citizens based on the changes. There is a scenario where people may not be, and that is if we know that the person renounced their Canadian citizenship before the birth of the next generation. We know that in the US, people would have to take an oath of citizenship there where they would have to talk about renouncing their former status, but that practically it's not likely that many people actually went through a process to renounce. So it is something that the government would look at when they're looking at these applications, if they have those kinds of records. And certainly if there was a records suggesting that the person did renounce their citizenship before the birth of the next generation, that would be a break in the link of citizenship here. But you know, it does seem that when we're talking about these older cases, that's less likely. It may be different for a more recent case, where, you know, maybe in more recent times, people were more likely to renounce citizenship because they couldn't hold, you know, dual citizenship or for other reasons. So that is something to be aware of, that if a person did formally renounce before the birth of their child, that child would not be a Canadian citizen. And I think we have time for probably one last question. Let me just see. I think we addressed the question about the spouse. So a lot of very, very specific situations. I'm just looking to see something sort of general about the process. But there is a question about people's names changing over time. This is a really common occurrence. You know, especially this person's talking about World War I. This is something that we see a lot. And in fact, when we submit the application, we do have to disclose all names used, all known names used by the person. So there are these scenarios, and it is something that needs to be explained and documented when possible in the course of the application, to demonstrate that we're talking about the same person. I mean, we certainly see this a lot too with women, married women, and other scenarios. So certainly does need to be explained. And if there is supporting documentation, and in some cases there are, in some cases there aren't, that, you know, would need to be provided as well to demonstrate that this is all the same person.
Right. So if we didn't get a chance to get to your question today, feel free to reach out. Our information is on the slide on the screen. You can reach out either to myself or to Valerie or both of us, and we'd be happy to answer any additional questions that you may have, or set up a consultation if you want to talk about your own specific scenario and how we can help.
Okay, so I think we'll end the webinar here. I just want to thank everyone for attending today's webinar, and of course a special thank you to Hilete and Valerie for sharing your expert knowledge. As Hilete mentioned, if you would like to discuss today's topics in more details, or you didn't get your questions answered, please feel free to reach out to Hilete and Valerie as seen on the screen. I also encourage you all to sign up for our e-alerts and follow us on social media, just to stay up to date on the latest developments in Canadian immigration. Thank you, everyone. Take care.
Thank you.